Hello, students, and welcome to our brief conversation on incorporation theory. So this discussion is tied back, is connected with our previous discussion on civil liberties, because this incorporation theory is about how the Bill of Limits, right? Again, the Bill of Rights, think Bill of Limits, the first 10 amendments of the U.S. Constitution are applied to the states, and how the federal courts and the national legislature, the President of the United States can act and respond to state behavior that might be a violation of the U.S. Constitution through this incorporation theory. Okay, so first we start out, once the Bill of Limits was passed and ratified, became part of the Constitution, there was a variety of court cases. One very important court case that kind of laid out really the limits of what the federal government can do or respond to within state and local governments as it related to the U.S. Constitutional Bill of Limits. Okay, so Barron v. Baltimore, an individual Barron had a property in the bay there in Baltimore, and during the buildup, the commercialization of Baltimore, more building was being done, the city was being developed, dirt was being displaced into the bay, into a wharf that Barron owned. It was impacting his ability to earn a living, and so he sued the city of Baltimore under the U.S. Constitution, right, in federal court, saying his rights his freedoms have been the government had negatively impacted his freedoms to earn a living, right? They were violating his right to property. And what the courts ultimately said is, right, they threw out his case. They said, no, you can't sue Baltimore in federal court based on U.S. constitutional provisions, because it is clear that when we think about the First Amendment or other amendments, right, that Congress, the language in the Constitution says Congress shall make no law. Okay? So the court said, well, no, this addresses Congress, right? The U.S. Congress. So if the U.S. Congress, the U.S. government wasn't a player in this lawsuit, you can't bring a suit in federal court under the U.S. Constitution. Okay? Well, that all changed when the 14th Amendment was passed. Okay, and the language and under the due process clause of the 14th Amendment, the courts recognized that they can now act and respond to government action or regulations at the state level because of that due process clause in the 14th Amendment. So what changed, what made that possible in the 14th Amendment was the language that was used. Remember, in Barron v. Baltimore, the case was decided based on the fact that the language of the U.S. Constitution said Congress shall make no law infringing on freedoms of individuals, right? Well, what changed was the language of the 14th Amendment stated that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens, and it goes on. Right. So now the fact that in the U.S. Constitution, it said that no state shall infringe on the privileges and immunities of citizens, that gave the federal government the ability to go in and enforce the freedoms, the civil liberties identified in the Bill of Rights, enforce that at the state level. So if the state was acting improperly, right? Let's say, for instance, the state was saying that individuals couldn't protest state government action. Well, before incorporation theory, before the 14th Amendment, the courts were saying that no, well, that's a state issue. The states have to sort that out. You have to address that at the state level. Now, through incorporation theory, federal courts could come in and say, no, that under the First Amendment, you have to allow citizens to protest their government, right? And redress their grievances and be able to have their freedom of speech, freedom of symbolic speech, to be able to do all these things. Right now, the federal government could come in and address those different freedoms of those different state actions. And right over time, there's a variety of cases that dealt with freedom of the press, freedom of religion, dealt with abortion rights, dealt with the Second Amendment issues, right? Unreasonable search and seizure. So you have right Fourth, Fifth, Sixth, Eighth Amendment issues that now the federal courts were dealing with at the state level. So that's how incorporation theory works and has been implemented at the state level. And that's what your discussion board question was about, right? How our society or how our country has changed after incorporation theory, and whether or not incorporation theory should be utilized to allow the federal government to respond to state action. So look forward to reading those. If you have any questions about incorporation theory, please reach out. Great explanation in your book if you haven't read it already. But again, remember, incorporation theory means applying civil liberties to the state and local level, and what allowed the federal courts and the federal government to involve themselves in these issues at the state level was the due process clause of the 14th Amendment. So hope you have a better understanding of incorporation theory. Again, reach out if you have any questions, but we'll see you next time.